Hello, I'm Ariel Pereira, Associate General Counsel for Legislation and Regulations, and welcome to the initial OGC video training. Legislation and regulations are the two ways that agencies can help to enact law or establish requirements that are binding and enforceable. The attorneys and the staff of the Office of Legislation and Regulations are experts in the legal and procedural requirements that govern the legislative and rulemaking processes. The team has put together a training that sheds light on the work of our office and that we hope is both informative and interesting. We hope you'll enjoy it.
Thanks, Ariel, and welcome to Legislation 101. I'm James Meritor, and this is Amanda Wallach, and we're attorney advisors in the Legislation Division of the Office of General Counsel, and we're here to teach you a thing or two about legislation. Go through a quick overview of what we'll be talking about today. We'll be discussing the two types of legislation, authorizing statutes and appropriations. And we'll be discussing drafting a bill. So that includes the drafting and developing process that the Office of Legislation is involved in. We'll be talking about the Office of Management and Budget Review, OMB review. We'll talk about what types of documents they look at and when they review them. And we'll also talk about the legislative process, which is about what goes on over on Capitol Hill.
James, it seems we have some breaking news. The Office of Public and Indian Housing, PIH, has decided they want to create a new program that will give everybody in the country a house. So they're going to require some legislation. Assistant Secretary Winfrey has sent us a summary of what she wants the legislation to say. She wants us to have flexibility on the type of housing we're going to build. She doesn't want it to be anybody's second home, and she wants us to have 5-year authority to be able to build all these houses.
Okay, so before we get into what exactly we'll be drafting, let's talk about, as I mentioned earlier, the two different types of legislation. The first type is appropriations. Appropriations is generally going to be a 1-year funding for government programs. Authorizing language, on the other hand, is going to be permanent and will authorize the government to take a certain program or some other type of activity. And this authorizing statute can be valid for a single year or a defined period or permanently. The main difference between authorizing and appropriating in this sense is that authorizing language is usually presumed to be permanent, whereas appropriations is presumed to only last for that fiscal year. And then later on, we'll talk a little bit about a hybrid between these two, which would be the budget general provisions.
This is an example of an appropriations language or account language. It is actually from the 2015 appropriations bill for the Public Housing Capital Fund program. As you can see, it has the specific authorizing statute that it is funding here, Section 9 of the United States Housing Act of 1937. It has the exact amount being appropriated and the length of time for which those appropriated funds are available. This account language also has some provisions that override or provide alternative requirements for the authorizing statute. This is not uncommon, but it's important to remember that the overriding language is only good for the period of time that the money is available. Another thing to remember about appropriations language is that according to Article 1, Section 7, Clause 1 of the United States Constitution, or the Origination Clause, all bills that raise money for the federal government must begin in the House of Representatives. The Senate can propose and amend other bills, but everything that raises a meaningful amount of revenue for the government has to begin in the House.
So Amanda did a great job talking you through what an appropriation statute looks like. So I'm going to talk to you a little bit about what an authorizing statute looks like. As you can see on the screen, this is Section 3 of the Department of Housing and Urban Development Act. This is what created HUD back in 1965. So you can see the statute establishes at the seat of government an executive department to be known as the Department of HUD, and also authorizes the secretary to supervise and direct the department. As you can see from the language, there's no mention of the word authorize or any variance thereof. You just have to know from looking at the statute that is authorizing a program, or in this case, an entire department. Now, as I mentioned earlier, there's a sort of hybrid in between authorizing language and appropriations language, and this would be a budget general provision, or GP. I say it's a mix because it's going to look like authorizing language, like the slide we looked at before, but it's going to act like appropriations language. Although it is part of the appropriations statute, which is only 1 year authority, it's going to look like the authorizing language. So the default of the single year authority still applies. GPs are often the vehicle for HUD-related funding. If you think about it, appropriations is something that Congress should be addressing each and every year. They might not do it in the traditional format or on time, but they will be addressing appropriations at some time. So this is a good way to bring Congress's attention to something that we might not otherwise have been able to. As you can see in the picture below, that is the President's budget. It's actually a huge document consisting of several parts, and for HUD's purposes, it's the appendix that actually matters.
After talking with our office, the Office of Public and Indian Housing has decided that a standalone authorizing bill is the way to go. This is because it's permanent authority, and by being a standalone bill, it will really bring attention to what they're trying to do. And so our office begins the process of developing and drafting the legislation. The first thing to remember whenever you're drafting legislation, or to figure out, rather, is where the new statutory language is going to live. The United States Code, or USC, is a compilation of laws passed by Congress and signed by the President, put together by the Office of Law Revision Council in the House of Representatives. They've taken all the laws of our country and grouped them together based on the subject matter, and then used a numerical system so that we can find specific provisions we're looking for. Generally, appropriations acts are not included in the USC. This is because, as we discussed, appropriations language is usually only good for 1 fiscal year. Exceptions might be provisions that have certain words of futurity or indicate that they're good for more than 1 year, ones that amend the authorizing statutes, or certain things that extend for so many years that it's good to put as a note to the USC section. HUD statutes also have a special relationship with the USC. Certain titles of the United States Code, like Title 26, the tax code, have been passed into law as a single block of text. Therefore, when you amend the tax code, for example, you actually are amending Title 26 of the USC. This is not the case for HUD laws. While Congress has passed many laws that deal with HUD, those remain separate, individually passed laws. There are USC sites, but those are finding aids only. So when we draft a change or amendment to those underlying statutes, we are in fact amending the underlying statute and not the USC.
So there are a few key dates in the statute that we'll be talking about here. The first is the date of approval. This is the date that the President signs the bill and is otherwise known as the date of enactment. Second date is the effective date. The effective date might be the same as the date of approval, or it might be a different date, depending on what is in the statutory language. So if the statutory language calls out, say, February 1st, 2017 as the effective date, but the date of approval, or the date that the President signs it, is December 15th, 2016, then that month and a half, the bill would not be effective even though it has been enacted. The third date that we'll look for is the expiration or sunset date. And this is the date at which the program would expire, or the authority to run a certain activity would expire. Not all bills, just like with effective dates, not all bills will have this language, but they may have the language if the Congress wants the bill to expire at a certain time. Sometimes you may find that you're drafting language and it would conflict with another statute. In this case, it may be appropriate to use notwithstanding language. When you use notwithstanding language, you want to use it very specifically with a specific provision of law. If you use it generally and say notwithstanding any other provision of law, someone will usually think of another provision of law you still want to be incorporated and still want to apply in that given situation. So it's better to be specific and call it a specific provision than to be general and just say notwithstanding any other provision of law.
After all that, our office and PIH have crafted a beautiful piece of legislation known as the Opportunities for People to Reside in Affordable Housing Initiative Act of 2017, or the OPRA Act for short. As you can see from the draft in front of you, The Secretary is authorized to implement a program to provide free housing for everyone. Just as Assistant Secretary Winfrey asked, we have a diversity in the types of housing we can build: single-family, multifamily, and manufactured housing. But we still have a lot of wiggle room in case we think of another type of housing later on. There are also exceptions per Assistant Secretary Winfrey's request. Note, we can't build a house for anyone whose annual income is over $500,000, who already owns a home, or who believes the Washington Nationals are overrated. This is a bill that has a sunset date. Now, Assistant Secretary Winfrey originally asked us for a 5-year authority, but after further discussion, we decided we wanted to extend it until December 31st, 2025. Finally, there's an authorization of appropriations of $10 billion a year for each year this program is active. It's important to remember that this is just an authorization of appropriations. It doesn't actually provide any money to the program. Instead, Congress has to pass an appropriations bill in order to give us that money. They're not obligated to go up to $10 billion a year, and in fact, they're not actually obligated to appropriate any money. And in this case, appropriating $0 is perhaps a real possibility.
Okay, Amanda, so we have some great news. The Department of HUD is happy with this language. We've gotten it cleared, and we are ready to send it over to OMB. So we're looking now for OMB's approval. OMB, or the Office of Management and Budget, is responsible for making sure all the agencies are on the same page and they're working together. We don't want to send something over to Congress that another agency has a major problem with, and then the president winds up not signing after we get through both houses in Congress. That would be embarrassing. So real quick, we'll talk about what requires OMB clearance. The first thing is administration-initiated draft legislation. That would include this Oprah initiative we've been talking about. The second thing would be the administration comments sent to congressional committees regarding bills introduced in Congress. We'd also want OMB clearance for agency congressional testimony. So if an agency official gets called over to the Hill to testify in front of a congressional committee, they're required to submit official written testimony. That testimony, before it can be sent to Congress, has to go to the Hill first. The last thing would be agency reports submitted to Congress. So if Congress requires us to submit some report to them, we have to submit it to OMB for their approval before it can go to Congress.
OMB has very specific requirements to clear items that are coming out of agencies. For legislation, HUD works with the Legislative Reference Division, who coordinates and clears our legislative proposals. In order to get them to clear, we have to submit certain items to OMB. First, we have to submit the proposed bill text. This is the draft of the Oprah initiative that we've already looked at. Then we have to include a section-by-section analysis. With the Oprah initiative, it's really easy to look at the draft text of the bill and understand what it's trying to do. However, sometimes bills are a little bit more technical, changing a 30 days to a 60 days, a shall to a may, or simply adding in a sentence in the middle of a section. There, it's a lot harder to read the text and understand the changes that it's creating. So, a section-by-section analysis tells, in plain English, what the bill is doing. Next, we have to submit a document called a Ramsayer. Christian Ramsayer was a United States representative from Iowa from 1915 to 1933. He introduced a rule in the House that was adopted in 1929 that requires committees, when they pass a bill out of the committee to send it to the House floor, to include a document that shows how the current statute would be changed by the proposed bill. This document has become known as a Ramsayer after the man who introduced the rule. So we have to send to OMB a markup showing how the current statute would be changed by the bill we are proposing. Just as with the section-by-section analysis, this helps OMB figure out exactly what changes we're proposing. Finally, we have to send OMB drafts of transmittal letters to Congress. HUD cannot introduce legislation itself, and so we have to find members of Congress who are willing to do it on our behalf. In order to do this, we have to draft a letter to them explaining what the bill does and asking them to help us. We have to send drafts of these letters to the Legislative Reference Division.
You may be asking what was involved in the OMB clearance process. This will involve coordinating and soliciting opinions with other interested agencies. So OMB will receive our document, our OPRA initiative, and they'll take that and they'll see what other agencies think about it if they're interested. This is called the LRM, or Legislative Referral Memorandum process. The LRM process for HUD originates in our office. We receive LRMs from OMB. We determine which offices within HUD would be interested in the LRM, and then we collect and consolidate and send those comments back over to OMB. OMB will also consult with the Executive Office of the President. They'll review the document itself, and they'll work to resolve any issues between us and other agencies so that we can get final OMB approval. And this is all governed by OMB Circular 819.
Throughout the legislative process, there are several other important documents that OMB is responsible for. One is the Statement of Administration Policy, or SAP. When a bill is proposed in Congress, OMB may issue a SAP, which is an official communication from OMB on behalf of the President explaining the official administration position on the piece of legislation. This helps Congress figure out how the President feels about the bill and whether he or she will sign the bill if it's passed. Next is an enrolled bill memorandum. When a bill is passed by both houses of Congress before it is signed by the President, it is known as an enrolled bill. When this happens, OMB asks agencies to submit letters to the director of OMB explaining how the bill would impact agencies and whether the agencies feel the bill should be signed into law. OMB then takes these letters, consolidates them, and sends a letter to the President on behalf of the director of OMB recommending a signature or veto.
Okay, great news, Amanda. OMB is approved. They sent it around to other agencies. They were okay with their language, and we are ready to send it over to Congress. But before we do that, we're going to talk a little bit about the legislative process. So this isn't so much about what goes on over at the legislation side of things or what happens on the Hill. This is more about what happens from our perspective. So we'll just be touching on how a bill moves through Congress. As you can see on this slide, we have a chart of how a bill may move through Congress. We're not going to say Schoolhouse Rock was wrong, but it was a little simplistic. There are many different paths a piece of legislation can take. It usually originates in a committee. There may be a hearing involved. It then moves to the floor of that house, and then it has to repeat the process on the other side. These processes don't have to take place consecutively. They could take place concurrently, and then it moves on to resolve differences at conference, and then up to the President, hopefully for his signature. For agency bills, our Office of Congressional and Intergovernmental Relations is responsible for finding a member of Congress who would be interested in introducing and maybe even sponsoring our bill.
Bills in Congress have to go through the committee system. This slide shows the committees that are responsible for HUD-related legislation in the 114th Congress. As you can see, they're structured pretty similarly with some slight naming differences. Both the House and the Senate have an appropriations committee to deal with appropriations bills. That appropriations committee then has a transportation, HUD, and related agencies subcommittee. Authorizing language goes to different committees. In the House, that's the House Financial Services Committee and the Housing and Insurance Subcommittee. In the Senate, that's the Senate Banking Committee and the Housing, Transportation, and Community Development Subcommittee. This slide also shows the names of the chair and ranking members of each of these committees and subcommittees. Keep in mind, however, that these are the names for the 114th Congress. These names will change in January when the 115th Congress begins. But back to our story. HUD has found a very kind and generous member of Congress who will introduce our bill. Unfortunately, it just sits there and never gets a hearing.
So Representative Gayle King comes to the rescue. She heard about our idea and wants to do something similar, but wants to do it in an entirely different way. So she then asks HUD for technical drafting services, otherwise known as TDS. We like to give things acronyms here. This is a service provided to Congress, again, under OMB Circular A19. Normally, we'll receive bill language or maybe even a concept from a member of Congress, and it's our job to mold that concept or bill into language that we think would be acceptable to HUD. That being said, this isn't an actual official proposal from HUD or the administration, and OMB's clearance is not required, but they should be informed of this process happening. So after the TBDS is submitted back to Representative King's office, the legislative process begins all over again. Through all of this, the bill is generating
legislative history. Legislative history can take a variety of forms. It can be in the form of a report from a committee when they pass a bill and send it to the floor. It can be in the congressional record, which is a record of things discussed on the floor of either chamber. It can be in the form of committee hearings, even in the form of previously introduced bills, which allows you to see how a concept has changed or stayed the same over time. The problem is, not every bill has good legislative history. And sometimes, even when it is present, when you're looking for legislative history on a specific point, it's not always there on the point you're looking to research. Also, it's very important to remember that while legislative history is useful and important in resolving ambiguities and determining congressional intent, it is the language of the act, not the language of the legislative history, that is enacted into law. Legislative history can be very useful to help you interpret a statute, but remember, HUD is always bound by the text of the statute, not the legislative history.
Okay, Amanda, we have some more good news. As you can see on the slide, President David Palmer signed the bill. There may be a formal ceremony like what you see in the picture with invitations given out to key members of Congress or others that were important to the success of the bill. You note the little box of pens next to President Palmer. He may sign each portion of his name with a different pen and then hand them out as souvenirs afterwards.
After the bill is signed by the president, it becomes what's known as a public law. The public law goes to the Government Printing Office, GPO, who then assigns it a public law number. The public law number actually has two numbers associated with it. The first, in this case on the slide, 114, indicates that it came out of the 114th Congress. The second number, in this case 201, indicates the public law is the 201st public law that came out of that Congress. So by looking at the public law number, you can have a guess of when it might have been published or passed. So now that we have a public law, what happens next? For that, we turn to our colleagues in the Division of Regulations.
We interrupt this program for a commercial break.
Feeling tired, anxious, confused? Have a statute that guarantees houses for everyone, but somehow people still don't have houses? Well, my friend, you need a regulation to implement the Oprah Act. Call on the Regulations Division. We will work to turn your statutory dream into a regulatory reality. As the general contractors of the legal world, we add details to statutory plans to make them functional. We create the regulatory framework to make HUD's programs operational. The Regulations Division. If the Legislation Division rocks, then we rule.
Welcome back. My name is Samuel Pearson Moore. I'm here with my colleague, Heather Nodler, and we're members of the Regulations Division. Thank you, Amanda and James, for your help on telling us a little bit about Legislation 101. We're going to dive into Regulations 101. Heather's going to provide an overview and start telling you a little bit about what we do in the Regulations Division. Heather?
Thank you, Sam. To give an overview, this training is intended to walk you through the legal foundations of agency rulemaking. We'll talk about the distinction between legislative rules and guidance, something about which our office gets many questions, the various steps of developing and drafting a rule, and finally, the publication process. All is seen from the perspective of HUD and the Office of Legislation and Regulations. To piggyback on the work of our colleagues in the Legislation Division, we will be using the Oprah Act to provide examples of rulemaking in action. I will begin by covering the legal foundations, and then I will pass it over to my colleague Sam to talk about the more practical aspects. Let's dive right in. First, let's discuss the various reasons why HUD may decide to make a rule. This slide shows several various reasons, the first three of which are the most common ones our office sees. First, often a statute will direct HUD to promulgate rules to implement the statute itself. Second, rules can fill in a gap when Congress doesn't define procedures for implementing a statute or leaves terms in a statute undefined. Or perhaps a policy determination needs to be made at the agency level and codified in a rule. So for example, if the Oprah Act aims to provide a house to everyone, but it doesn't specify how income limitations are going to be calculated, HUD might use a rule to define those income limitations. Third, perhaps a policy call has already been made, but the agency changes its mind and wants to go back and undo it. In that case, a new rule must be issued to undo a prior rulemaking. The remaining reasons for rulemaking are less common, but nevertheless important to note. The public can petition HUD for a rulemaking, and if HUD determines that it wants to deny the petition, it must do so by letter or other notice. Or HUD may choose to implement the recommendations of an oversight entity, such as the Government Accountability Office or the Office of Inspector General, through a rulemaking. Next, I'm going to talk a little bit about the legal framework for rulemaking under the Administrative Procedure Act, or the APA. In 1946, Congress passed the APA. The APA defines rulemaking and establishes the procedural requirements for rulemaking, which is itself a form of lawmaking. Specifically, it requires public participation to protect democratic values. This is important because the executive branch is seen as less democratically accountable than Congress. Rulemaking ensures public participation through something called notice and comment, which ensures constitutional due process. Notice and comment requires HUD to give the public notice of its potential regulatory changes through a proposed rule and to give it the opportunity to comment on that proposed rule. Interestingly, the APA also provides an exemption to the notice and comment requirement for rules relating to agency management or personnel or to public property, loans, grants, benefits, or contracts. You might be saying to yourself, if you're at all familiar with the work of HUD, wow, this sounds like it covers a lot of the work that HUD does. So perhaps HUD is exempt from notice and comment rulemaking for a lot of its programs? Not so fast. There's an exception to the exception. So now I'll explain that by talking about 24 CFR Part 10, or HUD's Rule on Rules. Despite the APA's exemption, HUD still has to do notice and comment for the majority of its rules. Here's why. Initially, as I discussed, the APA said matters like grants did not require notice and comment. After Watergate, however, a whole bunch of agencies passed regulations in their respective CFR titles. These regulations served to waive the APA exemption so that it no longer applied and those types of rules required notice and comment. HUD, on its own initiative, created a Part 10 in 1979, which codifies the APA notice and comment requirements for HUD's previously exempted activities. However, given the need to expedite getting grant funds out and the time required to undergo notice and comment, HUD considered making changes to its Part 10. Not so fast, Congress said. The Fiscal Year 98 Appropriations Act required HUD to maintain its Part 10. Ergo, it still has to follow notice and comment rulemaking for all of those types of previously exempted rules. Interestingly, the FY 98 Act is an example of an Appropriations Act having permanency. And this is appropriate because it contained words of futurity. So next, I'm going to talk about another exception to the APA and HUD's rules. Congress decided to set forth the APA and its requirements, but as discussed, in some cases, it may decide to waive them. For example, Congress may authorize an agency to issue a legislative rule without notice and comment rulemaking in the form of a notice or mortgagee letter. Here on the slide, you see an example in the Housing and Economic Recovery Act of 2008, in which the Secretary can establish any of the requirements that are necessary to carry out its provisions by a notice, as opposed to having to go through notice and comment rulemaking. Next, I want to talk a little bit about HUD's authority to issue rules. Legislative rules emanate from statutes, not vice versa. That's because there's a hierarchy at which statutes are at the top. Rulemaking is also required where directed by statute. In some cases, the statute may specify the type of rulemaking that the agency must undertake. It may be formal, adjudicatory, or informal, which is another word for notice and comment rulemaking, which we're discussing here. HUD's authority to issue rules may be extremely broad, and that gives the agency much autonomy. So, for example, the Department of Housing and Urban Development Act, HUD's authorizing or organic legislation, provides HUD with such authority. It states that the Secretary may make such rules and regulations as may be necessary to carry out his functions, powers, and duties. In this example, in the example of the OPRA Act, while the statute itself does not direct HUD to issue rules, HUD nevertheless may do so under the general authority provided in its organic statute. So now I'm going to turn it back over to Sam to talk about legislative rules and guidance.
Thanks, Heather, for that great information about the legal foundations for rulemaking. We're going to talk about the difference between legislative rules and guidance. As Heather noted, this is a question we get often in our Office of Regulations. Heather also mentioned that the law or statute is required by is the top of the food chain. Below that would be our rules. These are also laws, but they would be found in the Code of Federal Regulations. And it requires a rule to change a rule, whereas a statute requires an act of Congress. And lastly is guidance issued by HUD, found on HUD's website. It can be changed by issuing new guidance. Let's dive in to determine what is the difference between a legislative rule and guidance. On your left, you see a stoplight. The stoplight shows you to stop. That would be a rule. The law tells you to stop or you're going to get a ticket. On your right, you'll see the ducks. The crossing duck sign warns you that ducks would be crossing. And if you don't stop, you might be considered recklessly driving and get a ticket for reckless driving. The ducks are a warning. They would be considered guidance in this scenario, whereas the red light is the rule telling you what the law is. A legislative rule, or the term rule, has the force and effect of law. The rule is legally binding on members of the public and entitled to deference and enforcement by the courts, provided the rule was issued in accordance with the APA. As Heather talked to you about, the APA has certain requirements that you must follow in order for the rule to be legally enforceable. A rule implementing the OPRA Act, for example, may provide for a definition of what counts as annual income. Rules are a primary vehicle by which agencies implement our laws, as well as general agency objectives. Agency guidance is designed to supplement statutes and regulations. They are considered sub-regulatory. They provide for best practices for complying with rules. They are not a legislative rule. That means that they are not subject to notice and comment or publication requirements. They are not legally binding or enforceable. Program offices may, on occasion, decide to provide for public comment so that people can give feedback on their guidance, but it's not statutorily required. Guidance documents come in many different forms, such as policy statements, policy directives, compliance directives, opinion letters, bulletins, and documents responding to frequently asked questions. The specific form does not matter. It is still guidance. A guidance document, as I noted, does not impose requirements on members of the public, and a court will not regard it as having the force of law. Guidance for implementing the OPRA Act of 2017 rule may specify the methods for determining annual income consistent with the regulatory definition, where the legislative rule would tell you what annual income was. Now that we understand the difference between a legislative rule and a guidance, we're going to go through the developing and drafting process of a rule. We're going to talk about how OGC works with different program offices, worked with OMB, the Office of Management and Budget, a term that was referenced in the Legislations Division presentation, how we work with Congress sometimes. It requires public participation from the public. This is not how a bill becomes a law in the legislative branch, but rather how the executive branch is involved in the rulemaking process. But first, we must determine, for implementing the OPRA Act, what type of rule do we need? So I'm going to turn it back over to Heather, and she's going to talk about the 3 different types of rulemaking.
Thank you, Sam. It's important first to note that rulemaking most often is a 2-step process. The first step is the proposed rule, and the second step is the final rule. This is the conventional route that we would use in our OPRA Act rulemaking. You can, however, bypass the proposed stage via an interim rule, which I will explain shortly. talk a little bit about the proposed rule stage first. This is where the rule exists in its infancy. After our office has discussed policy goals with program offices and obtained all of the necessary data, it will draft a proposed rule to tell the public, hey, this is the rule we are thinking of making. Then the public will have an opportunity to say via the comment process, great idea, or no, please don't do that. The public can submit comments online at regulations.gov, and those will be available for anyone to see. The time period and exceptions to the time period are laid out at 24 CFR Part 10. So for example, a proposed rule typically requires 60 days of public comment, and the preamble has to include any justification for a reduced comment period, no fewer than 30 days. There is one important exception that comment may be omitted if it's impracticable, unnecessary, or contrary to the public interest, and that is a standard that is very strictly interpreted. Another important note is that the Department of HUD Act, Section 7.0, says that all HUD proposed and interim rules issued for comment must first go to HUD's congressional authorizing committees for a 15-day calendar review period before being published in the Federal Register. So in this case, the OPRA Act rule lacks justification for any sort of reduced comment period, so it's going to follow the typical 60-day public comment period. Once HUD has gathered public feedback through the issuance of its proposed rule, it can issue a final rule. The same drafting and approval process as before takes place at the final rule stage. Under the APA, the final rule must include the following: a summary of public comments and HUD's responses, a description of changes from the proposed rule stage to the final rule stage, and all of those changes must be a logical outgrowth of the proposed rule. To explain, for example, in the OPRA Act rule, if HUD said at the proposed rule stage that people owned their houses outright, but in the final rule it stated that they had to share ownership with Dr. Oz, that would be a clear violation of the APA, because the final rule would not be a logical outgrowth of the proposed rule. That concept of co-ownership with Dr. Oz was not provided at the proposed rule stage, and therefore the public was not given notice. This rule would almost certainly become the focus of legal action against HUD. Additionally, it bears noting that final rules may not take effect until at least 30 days following publication in the Federal Register, and economically significant rules, those that have an amount of $100 million or more, require at least 60 days after publication to take effect. Next, I'm going to talk a little bit about the third type of rule, and this is the one I mentioned where we would bypass the proposed rule stage. This is the interim rule. An interim rule is a final rule that solicits comment. Typically, it's directed by statute, but in some cases, if a rule that HUD is making provides a benefit or flexibility, and a public comment exception applies, HUD may nevertheless want to solicit comments. When HUD makes an interim rule, it still has to issue a final rule letting the public know what it decided in response to those comments. Once again, as with the proposed rule stage, if comment is impracticable, unnecessary, or contrary to the public interest, it may be omitted. So now I'm going to pass it back to Sam to discuss the process of developing and drafting rules.
Thanks, Heather. That was really helpful. Now that we know we need a proposed rule and a final rule to implement the OPRA Act of 2017, let's discuss how the HUD's Regulations Division works within the agency to draft a proposed rule. The first thing we do in drafting the rule, after consulting with Program Office and Program Council, is draft what the rule will say and what the impact will be to the Code of Federal Regulations. How are we going to set forth the policy that will implement the statute in our regulations? We'll work with program offices and program council to discuss what that should look like and what language should be used. In drafting the language, we draft the language in accordance with the Federal Register Drafting Handbook. It's kind of like a blue book for regulatory attorneys. We'll also work with the Office of Policy Development and Research on the costs and benefits of the rule. The OPRA 2017 Act is a pretty big undertaking, which means it would have a lot of costs to actually implement the rule. It would also have a lot of benefits because it's providing houses to people. The PD&R office will provide the statistical analysis and the background in determining how to write up a cost-benefit analysis or a regulatory impact analysis on what's the impact of our regulation. This is one of the requirements consistent that we need to cover in our finding and certifications. In drafting the rule, it's our requirement, and it's the requirement of our office to ensure that we address all the findings and certifications that we are legally required to address in any rulemaking. Those would include Executive Order 12866, Unfunded Mandate Reform Act, the Regulatory Flexibility Act, and all other applicable EOs and guidance that tells the public that we've considered these different guidances and executive orders and our response to how this rule will act within those frameworks. Lastly, our office will identify and address concerns that might be raised by OMB during the OMB review process. Typically, these are the types of questions getting to why we decided to do the rule the way we did the rule. For example, why did we decide this group of people would be eligible for getting a house under the Oprah 2017 Act versus this group of people, and whether or not we thought about other alternatives before we made those decisions. After doing all of that, and we've drafted a proposed rule that is ready for clearance or a final rule, depending what stage we are at, we'll put the rule into something called internal HUD clearance. This is typically a 2-week process where program offices and program counsel have the opportunity to review the rule and provide comments to our office. We take those comments and we work with the office that is implementing or issuing the rule to resolve the comments before the draft can go forward. Once the draft goes forward, it's usually sent to OMB because it's found significant under EO 12866. Not all rules are found to be significant, and we'll get to that in a second. But rules like the Oprah 2017 Implementation Act, which had such a big impact, would likely be found significant, which means generally it would go to OMB for 90 days of review. OMB takes the document, it identifies interested parties, other agencies that might have an interest in the rulemaking that we're doing, and it sends our rule to those agencies to provide OMB comments. OMB itself will also provide comments on HUD's rule. All of those comments are consolidated and provided back to HUD. That's what we call an OMB passback. It's the obligation of HUD to respond to those comments and to respond to the comments and send it back to OMB. This might take 1 or 2 passbacks depending on how many comments are collected from OMB. HUD responds to all OMB comments, and then OMB will approve for the rule to go forward to publication. Now, I mentioned a significant regulatory action. Those are the ones under Executive Order 12866 that are subject to OMB review. 12866 defines a significant regulatory action to be a rule that has an annual effect on the economy of $100 million or more, or adversely affects public in a material way. These are economically significant rules that Heather had talked about just a moment ago. There are also any rule that creates serious inconsistency or otherwise interferes with action taken or planned by another agency. They materially alter budgetary impact of entitlements, grants, user fees, or local programs, loan programs, or rights and obligations of recipients, or they raise novel legal or policy issues arising out of legal mandates or president's priorities. Obviously, the Oprah's Act of 2017 would fall into that category. But given the breadth of the category, you would guess, and you would be right, that it happens a lot that most of our rules go to OMB for review. Now that the Oprah Implementation Act of 2017 has been approved, we get to move forward. So what's the next step? The next step, if OMB passes on review or OMB review is concluded, is the rule is packaged in HUD in a pink signature package. This package goes to our office, the Office of the General Counsel's Office, Program Counsel, and Program Offices, as well as the Secretary if the Secretary needs to sign it for signature. Once it's been signed, we then take that rule and we package it and send it to the Federal Register. And next is on to publication. The publication process is twofold. First, the rule itself, either a proposed or final rule, gets published in the Federal Register. And second, it goes to be codified in the Code of Federal Regulations. The Federal Register has 4 different sections. The first section is for the President, which would include executive orders and President proclamations. The second is for rules and regulations, which would include our Oprah Implementation Act of 2016 final rule. The third section is proposed rules, which would have included our Oprah Implementation Act of 2017 proposed rule. And the last is for notices, which could be notices of meetings that different agencies are planning, or requests for information, or Paperwork Reduction Act notices that give the public an opportunity to comment on those items. It's important to note the 4 sections because that's how you know whether a rule is a proposed rule or a rule is a final rule or interim rule. It will be placed in a section based on that. The other important thing to note about the rule process is the Federal Register Document Drafting Handbook, our good old blue book for regulatory attorneys that we mentioned earlier. This provides direction on how to draft different notices, rules, proposed rules, and rules to be placed in these different sections. It provides the amendatory information and the instructions on what we need to say to make sure that when the Federal Register receives our document, they know how to handle the document, where to place the document, and implement the document. I'm going to pass it back to Heather to tell you a little bit more about how the Federal Register works with our documents.
Thank you for that great information, Sam. So now that the Federal Register has published HUD's rule, we're really excited, and it's important to understand the various component parts of the rule. So I'm going to walk you through some of those. First, each rule has 2 main sections. There's the preamble and the regulatory section. The preamble functions much more like guidance. It provides background and helpful information, but its text does not actually contain the force of law. The regulation section, by contrast, is the actual regulatory language, which is later codified. This language is legally binding on HUD and the public. So under those 2 sections, the rule is broken down into multiple other sections, some of which you can see here on the slide. These include things like the name of our agency, the title and part of the Code of Federal Regulations where the rule will be published and codified, the 2 tracking numbers, the docket number, which is HUD's internal tracking number, and the RIN, which is OMB's tracking number, the title of the rule itself, which is the Oprah Act of 2017 Implementation and HUD Programs, again, the agency, the type of action it is, in this case, a final rule, the summary, which gives you an overview of what the rule does, specifically in this case, through this final rule, HUD ensures that you get a house, and you get a house, and everyone gets a house. Dates, such as the effective date, and then contact information for the person who worked on the rule. You can't see on the slide here that there are other sections that are really important. Things like the executive summary, the background, changes from the proposed rule to the final rule, public comments and HUD's responses, findings and certifications, amendatory instructions, and authority citation. Once the rule is published, HUD's work is for all intents and purposes complete. But the rule still has quite a bit further to go in its journey to becoming law that the public can use. So now I'm going to talk a little bit about the codification process. After HUD says goodbye to the Oprah rule, it will go to be codified in the Code of Federal Regulations, or the CFR. Upon its effective date, it becomes the law of the land. Specifically on that date, it's codified in the electronic CFR, or eCFR, which is a very important tool that you can use online. And later, it will be printed in the print edition. It's important to note that sometimes there are separate compliance dates, and these are usually for rules with multiple components where affected entities may need more time to come into compliance with specific provisions. Another important fact to note is that the CFR will contain citation dates back to the publication in the Federal Register. So if you're looking at a codified rule, you can actually trace back where those parts were published in the Federal Register. That can be a very helpful tool. Once again, this is the law. If HUD wants to make any changes to the Oprah Act implementing regulations, it has to start all over again with a new rulemaking. So after codification, the next step is usually guidance. Program offices will work with their program counsel and possibly with support from our office to draft and issue guidance, as Sam described earlier. And now I'm going to pass it back to Sam.
Thank you, Heather. That was really informative. Now that we've told you a little bit about the legal foundations for rulemaking, the difference between legislative rules and regulatory guidance, legislative rules and guidance, how the proposed rule, final rule, and interim rule process works, and how a rule gets drafted and published in the Federal Register, you should have all the tools necessary to understand the Regulations Division's jobs here in the Office of General Counsel at HUD. We thank you for the opportunity to speak with us, and we provide you our contact information if you have any questions, and we're going to turn it over to Ariel to close out our presentation today. Thank you, Heather.
Thank you, Sam.
We hope you enjoyed the training. As Sam says, please feel free to contact any of us. We like to think of the Office of Legislation and Regulations as the office where everybody knows our name. Given the cross-cutting nature of our work, chances are that if we haven't worked with you already, we probably will in the very near future. So please feel free to reach out. And we also very much welcome and appreciate any feedback you might have on how to make this training better. Thanks for watching.